Okay, so we're going to go ahead and get started. I can't see if you've got questions, this is ancestral estate planning. You can hopefully see that on the screen. My name is Michael John Neal. We're going to give you a broad overview of estate records and probate with the intent of getting you started and giving you some ideas about where to go with that aspect of your research. If you've got questions, put those in the chat. Can't see the chat right now, but when we get done with the presentation, I'll go through those and see which questions I can answer on the fly, and we'll take that with that approach. When we're looking at estate records, I didn't mean to hit the back button. We're talking about when your ancestor, your relative died, how their estate was settled up, how their property passed from their ownership after they were deceased to their heirs or to whomever they decided what they wanted to have see that property. And first of all, your relative has to have something. They have to have some property. If your ancestor dies penniless, then chances are there's not going to be a probate record. And that's just ancestors that don't have much money in general leave fewer records. That's just the nature of it. But one of the things you might want to try first is to determine, did your ancestor have property? And local tax records, and a lot of the records that we're talking about in this presentation in the United States are all local, usually county records. And that's where you're going to want to start your search. Personal property tax records may give you some idea if they own real estate. Census records in the United States, if we're talking about 1850, 1860, those enumerations will give you some monetary amounts of your ancestors' real estate and personal property that would then suggest to you that you would want to look for a probate record or an estate settlement after they died to see how that property was dispersed to their heirs or their family or to whomever they determine that should be given out to. The records of how that property is dispersed can help you document relationships. It can indicate where people have migrated if you can't determine where they migrated and things of that type. That's the main reason that we want to look at those records, because it can help us document relationships and sometimes migrations as well. And let's see if I can go to the next slide here. The documents that transfer property. There are several different documents that your ancestor or relative might have used to transfer property. The first one that you see on your slide are probate records. And those are court records, usually local court records. So we're talking items at the county level in the United States. There may be other court records. A probate court will handle the probate of the will and things of that type. If there was a extended legal battle over the property, there might have been records in another court. A non-probate court might have heard those court cases if there was some fight or a state squabble. They're court records still, but they're not probate records. And those records in some places may be in a separate court, not the probate court. There may also be land records. If your ancestor owned real estate, then there might be some land records after he or she died that handle how the property was transferred from the deceased person's ownership to the new owners or to the heirs. It's also possible that your ancestor, before he or she died, deeded property to their children, their spouse, or whatever, for a couple reasons. They might have wanted to make certain it went to whom they intended for it to go, and they might have wanted to try to avoid all that property going through probate. That would be another reason why your ancestor might have actually done deed work before he or she died. There may be other transfers of property, particularly chattel property, household goods, and things of that nature that are not real property and not like cash or things of that sort. Often things of that type, if they're not mentioned in the will, they might leave no record of who got some of those smaller personal items. Although you may see a will or an estate settlement that does document what happens to the chattel property. So you want to take a look at that. In terms of the probate and settling up your ancestor's estate, your ancestor either left a valid will when he or she died or they did not. If your ancestor had a will that was, and just because they had a will, there was no guarantee the court would say it was valid and send it through probate. But if the judge approved the will and what we call admitted it to probate, then they are said to have died testate. If there was no valid will or they did not leave one at all, then they're said to have died intestate. And that matters because if they die testate with a will, then the will dictates what happens to their real estate, cash items, or what have you. If they die intestate without a valid will, then usually in the United States, state statute dictates how that property is to be distributed upon the person's death. If your ancestor left a small estate, and this is also true even today, if it's a very small estate, there might be no need for probate. If your ancestor died without anything whatsoever, there might not have been a need for probate. You still, though, should take a look, even if you think great grandma, well, she didn't have anything, there'd be nothing to probate. You still might want to take a look because there might have been some legal reason why they had to run her estate through probate. I've got a relative who died in 1923, and all that was in her probate settlement was a $50 savings bond, but they had to run that savings bond through probate. But there was nothing else in her probate except for the $50 savings bond. If your ancestor had a will, this is a really broad summary of what happens in that process. The will would be filed with the appropriate local court, which you're going to want to determine for your area, and we'll talk about that in the last slide, where to find some of these records. The judge would approve the will. The executor or the executors are the individuals that are appointed in the will with distributing the property. They would be approved. They may have to post some paperwork. The will would be recorded. And then in with that set of records, the will is just a starting point for that. There may, in that packet of papers or in those probate records, there will be other documents where they have to report to the judge or the court basically how they are working through the process. The items they own have to be inventoried and appraised. There may be a sale, an estate sale. Those documents would be in the local probate court records. If your ancestor left a will that was denied, which sometimes does happen for a variety of reasons, that denied will wasn't admitted to probate, but it still may be filed with those records. And it can be interesting to read that, largely because sometimes you can get an idea of why it was denied probate if the court doesn't specifically indicate that. One of the things that if your ancestor left a will, or sometimes this can be done with a deed, but they might have given their spouse what's called a life estate in their real property or their land. And that life estate, this can also be done today for a variety of reasons. But when if they give their spouse a life estate or giving it to them for their quote unquote natural life, then that was done for, usually in an earlier time period, that was done to prevent a subsequent spouse, if the widow remarries perhaps, that spouse would not be able to do anything with that property because the person who has a life estate, if they're given that, they can't sell it, they can't bequeath it, they can't mortgage it, they can get income off of it, but that's all they can, they have to pay the taxes, but that's all they can do with it. They can't sell it or mortgage it or encumber the title. And so if your ancestor gives their spouse a life estate, that's one reason why they would do that. It protects that person from somebody else trying to take it. And usually what happens when a life estate is given, then it will say at the death of that person is to go to somebody else. Typically it's the children or maybe other heirs. If your ancestor had no will, as we mentioned before, then the property would be distributed based upon intestate probate procedures that in the United States, state statute dictates how that has to be done. And in the United States, the whole process of probate or settling up an estate is determined by state statute. The time frames that have to be followed, how long you have to wait to do certain things, that's all determined by state statute, which also determines who are called the heirs at law that have an interest in the estate of someone who is deceased. State statute dictates dictates that. And in some states, those have slightly changed over time. The records of the probate court are probably the first place where you want to look to see how your ancestor's property was dispersed or settled up. But those are not, that's not the only court that might mention your ancestor's estate. There may be other court records outside the probate court that might give you information about how that estate was settled up. If there was a significant fight over the estate, or maybe when the relative died, they didn't even go to probate. They just kind of paid the bills and went on, as some families would. You couldn't get by with that today, but in an earlier time period, some families would do that. They would, great grandpa died or whomever, they had the funeral, paid the bills, and they went on. And then if at a later point in time there was an issue, because at a certain point in time there's always an issue, they would have had to have gone to a different court to deal with the title of that property. If there's a significant legal dispute, that might have been heard in a separate court. And we mention those other courts because separate courts keep an entirely separate set of records. And just because you've looked in the probate court doesn't mean there couldn't be something in another court. A guardianship might be how some of the affairs of your ancestor were settled, particularly if one of the heirs was underage. And in some jurisdictions, in some time periods, the guardianship court is a separate court from the probate court. And again, this varies from state to state. But if it's a separate court, it's a separate series of records. And that would be more applicable if one or more of the heirs was not of the legal age of majority, which is typically 18 for a female and 21 for a male, but that can vary a little bit. But again, that's set by state statute. Land records. Land records can also be, and again, these are local county type records that we're talking about in the United States, would be another place where you might see how your ancestor's property was dispersed, either after his death, or as we mentioned before, your ancestor might have tried to avoid probate like people do today by deeding property before they die. So you're going to want to go through those local land records. The will might have served as the deed, where the will says who's to get this piece of property or who's to get that piece of property. The property might have been transferred by court order. If the will doesn't mention the land or there is no will, the heirs may squabble over who gets what part of it and how it's to be allocated. And they have to go to court to settle that. And in that case, the court order, the judge may order the property sold. And the judge may be the quote seller on that deed because he's ordered it to be sold at auction or what have you. The overhead mentions the partition suit. In terms of real estate, what a partition suit is basically when the heirs cannot agree upon how to partition the land into maybe the widow's part and the other heirs' parts, they may go to court and have the judge do it or have the judge appoint. Usually it's 2 or 3 individuals that are familiar with local land values and how the property is farmed and whatever. And those individuals will say, this is the part you should assign to the widow. This is the part you should assign to the children, break it up into their little shares. And that's what'll happen. If your ancestor lived in Kentucky where it's hilly and the terrain is not flat and all that, it might be difficult to say, here's 80 acres for the widow and here's what we're going to give the kids. And he might just say the whole thing is sold in one chunk. But that would be a court record. And then there would be a land deed for that, transferring that title. The other kind of deed you might find, the one that's mentioned in the last bullet point in the overhead, is a quitclaim deed. And a quitclaim deed, after the person dies, the heirs to that property sign off. Sometimes they're selling it to a brother or a sister, or they might be selling it to a neighbor. But that quitclaim deed, sometimes referred to as an heirship deed, is where, and all the heirs would have to sign off for that to be valid. And that's one reason why it's good to get that deed if you can. If there's a quitclaim deed or an heirship deed usually it's after the surviving spouse dies. The reason to get that deed is all the heirs will have to sign off on that deed for that transfer of title to be valid. And that can be a place to find out about where somebody ended up that you didn't know what happened to them. If there was an heir that could not absolutely be found for one reason or another, then that may be referenced in the deed. There also, in that instance, might have had to have been a court case if there was somebody that could not be found to handle that, because the judge or someone will have to acknowledge that, say we tried to find this person, and so on and so forth. But that quitclaim deed can be helpful because all the heirs will have to sign off on that. Locating the probate and court records that we talked about. We alluded to earlier, most of the court records and the probate records in the United States.
It's been working. Now it's not working again.
Hang on, can you hear me now?
It's all good, Michael. Carry on.
Okay. In terms of locating the probate and the court records, you're going to want to start in the county courthouse
today or
Yeah.
in most U.S. counties. There are some jurisdictions in the United States where these are town records in Virginia and parts of New England, but for the most part, these are county type local records. That's where you're going to want to start for probate and court records, keeping in mind sometimes there are two separate courts. The individuals you want to look for, we could just simply say, well, look for any relative's probate. I like to, in addition to the ancestors, because sometimes you can't look at everything you might want to look at, the best people to look at besides your ancestors are any relatives you know that died without descendants, because how that estate was settled, the legal process they had to go through, oftentimes those will mention the heirs to their estate. The heirs might not have all inherited for one reason or another, depending upon if there was a will or not, but oftentimes those heirs would have to have been given notice that this estate was being put through probate. And so that can be a place, if the person had no children, grandchildren, nieces and nephews or cousins, depending upon the family structure, would have been their heirs. And there could be notice in those records. I was looking at one today where my uncle died in California in 1973, and he had no children. And his property, he had a house and a little bit of money. His property, after it was sold, went to his 4 living siblings. And then he had 5 or 6 deceased siblings, all of whom had children. There's a lengthy list of names and relationships and addresses. So they're in that probate for him in 1973. I've got a list of all his siblings and then a lot of his nieces and nephews, where they were at across the whole United States at that point in time. Some of these records are online at Family Search. And of course, they're online at Family Search. You don't have to get the credit card out to pay for those. Others of these are available at fee-based vendors. I would start looking online at Family Search. Not all of them are online, but looking in the Family Search catalog would definitely be the place to start looking for these probate and court records. And of course, the time period when you're going through these, you cannot probate someone's estate until dead. That's a joke. They've got to be deceased first. So when you're thinking about a time frame to look at, you'll want to start with when you think the person died and work forward. Don't just look for a year or two. Look for quite a while, after maybe 15 or 20 years afterwards, because sometimes these cases don't get filed until they have been totally settled up. And if it's one where there was enough money to fuss about, sometimes they drag out for some time. So look for a while. Don't just look for a year or two and quit. Look for a little while after the person died when you're looking in that index for that individual. The land records in the United States is pretty much similar to the court records in terms of where these records are located. They'll be at the local county courthouse in most U.S. counties, towns and cities in some part in Virginia and parts of New England, for where we have independent cities. But these, again, the land records that we are talking about, where your ancestor may be dispersed of his property before he or she died, or where there were some deeds after he died to settle it up, these are local records. They're typically, it's in what's called the recorder's office. That name can vary because we're talking nationally here, but it's a recorder's office as the usual name for that. Family Search has digitized a significant number of these land records. They were originally on microfilm, but now they're all digitized. When you're searching them, because land records and the court records we talked about in the previous slide, oftentimes family search hasn't indexed these yet, because a lot of these are, to really oversimplify it, they're pretty much written in notebooks in loose leaf form. And indexing them is a very time consuming and extremely tedious process. So we're not to the point where you can type in a name and find these. You'll have to search the indexes that were created by the record agency that originally held the record. And if family search is microfilmed or digitized, the records, they have microfilmed the finding aids that were created at that original record level jurisdiction. For land records, there's two types of indexes. There's a grantee index, that's an index to the buyer, and there's a grantor index, that's the index to the seller. And you'll want to, if you're looking for when your person sold it or disbursed it, you'll want to look in the seller index or the grantor index. And that's when we're talking about settling up in the state, we're usually looking for people in the grantor index, because it's they're the seller or the person transferring it. When you are looking in those grantor indexes for land records that document the settling up of an estate and how the land was transferred, don't look for your dead ancestor because dead people cannot sign legal documents. That's called fraud. That was joke number 2. But when you're looking for those deeds after the person died, look for their children. Those are the people to look for in that seller index, because their children or their heirs, if they had no children, will be the grantor on that document. If there was a lot of animosity and whatever, and they had to go to court, the judge may be the grantor on the deed. But start by looking for the heirs, because the heirs are after the person died, they're the ones that would have to sell that deed. And make certain you look for all of them, not just your direct ancestor, and forget the others, because there may be 10 people as sellers on that deed if there's 10 heirs. But typically in the records that we're talking about with these land records, it's only in the grantor, the sell or index, one time. So and whoever's name is first gets put in the index when it's these original indexes that were created by the original agency that had the records. So that's why you've got to look for every heir, not just your direct line, because if there's 15 heirs, it's in that index one time. You've got to look for the right name if you want to find it in that index. We're going to wrap up with some general suggestions for locating local records. I would start with the Family Search Wiki for the state, the local area in particular, because there are some nuances from one county or independent city to another. I would also search the Family Search catalog for these records that we're talking about, the court, probate, and the land records. They're local records, so they're county or town records in certain areas. They would be cataloged in the Family Search catalog under the county or the town. So you've got to search the catalog at that level. They're not going to be at the state level in the Family Search catalog, because if they're digitized and unindexed, they'll still be in the catalog. You view them digitally. Contact the local genealogical or historical society. They're locals. They may know of some records that were not microfilmed or digitized, or some unique issues with the local records. They may be more familiar with them because they've worked with them, or they related to half the county, or whatever the case may be, and they may be able to give you some help. The same thing kind of goes there with the third bullet point. See if there's a group on Facebook or any other social media dedicated to that county. If there's none for the county, look for the state and ask about, I'm looking in Coshocton County, Ohio. What's the best way to access the probate records? Are there issues with those? What should I know? I've looked for somebody, I can't find their probate, can't find this. And they may be able to give you some suggestions, because with a lot of these local records, there can be nuances to them from one state to another because of state statute being different. There can be differences within one state over time, and just because of the idiosyncrasies of an individual clerk. And just kind of to reinforce the concept here, reach out to locals that might have researched in the area and could give you some location-specific advice, keeping in mind those people might not live in the county. If it's a place where you've got a lot of people and you've researched it for a long time, you may be very familiar with those records and how to access them, even though you've never lived there or haven't lived there in 50 years. But reaching out to a local is what you want to try to do. But I would start with the Family Search Wiki, and I would look in the card catalog under that county or town or village to get started with that. But you do want to make certain that your individual had some property. No money, there's probably no records of an estate settlement. Probably, you still want to take a look. And then there's just a few other, I'm trying to make sure I stay within our time frame here. They might have given a life estate. State statute dictates what happens if there's no will. Today, people can avoid probate. There's a variety of legal ways you can do that. Your ancestor in 1850 or 1880 might have avoided probate. I have one, and he had 400 acres of property. There is no probate settlement for him when he died in 1883 because of how he and his wife set everything up 4 or 5 years before they died. When they died, they owned nothing, and that was intentional on their part. People do that today. I realize we as genealogists hate it when it happens to our ancestor, but just like today, some people did choose to do that. That ends the PowerPoint part of my presentation. I do thank you for listening, and I'm waiting for my screen to resurrect itself. So if there's questions in the chat. I'm not seeing those yet. I do thank you for listening. I'm scrolling through those. I do thank you for attending today. I'm going to grab through a few of these questions here really quickly. One is, when an ancestor dies and land ends up with the wife, will she be listed as the grantee? Part of that depends upon the time period. In 1850, and I'm just going to use Illinois as a quick reference point, if you bequeath property in a will, real estate, there would be no deed at all. The will was the deed. Today, if you would bequeath property in a will, there would be a cleanup deed or an estate settlement deed, just so there was a legitimate deed that transferred that ownership. But if it's in 1850, you were not going to find that. The deed isn't, the will is the deed in a lot of these cases. And I'm just kind of grabbing some of the locations here. I had a person ask about Manhattan or urban areas. Urban areas, the law is the same as it is in the rural areas of the state. It can be more challenging just given the demographics and the population. I would suggest, I know for Cook County in Chicago, Illinois, there's a very active genealogy Facebook group. I would post those questions there because there will be individuals there that can help you navigate Chicago, St. Louis, Manhattan, Philadelphia, or whatever urban area that is. There may also be probate records may be referenced in the newspaper. You may see the details of your ancestor's will in the newspaper. Now, today, people would lose their sanity. I'll use that word. If the details of their father's will was in the paper with the amounts and everything, it would not go over well. But you may find that in 1930 or 1880 where those details are in the newspaper. Now, that can be helpful if you're in what's called a burned county where the court records and the probate records no longer exist. The newspaper may document some of that. It will not give you the detail that is in the probate record, but it will give you a little bit of that. The good thing about newspapers mentioning probates, probates are county records. You've got to know where the property was at to find the court record, probate record of that. If you don't know where the person died, if you do a global newspaper search, something may pop up about their estate being settled, and then that will give you the county to help you find those actual references. Now, the question about if there's intestate, does it always end up in court? The one thing to remember is these rules vary from one state to another, and what's true in one state today is not necessarily true about what's in a different state. Typically, if there's enough property to fuss over, it's going to go to probate court, will or not. But again, what's true in South Carolina is not necessarily true about what happens in California, which is why you want to get a rough understanding of what happens in your specific state where you have research interest. To kind of wrap it up with this quick comment, when we settled my father's estate 2 years ago, I did not ask my third cousin, who's a lawyer in Seattle, for any kind of advice whatsoever, because it's different in Washington State than it is here. Yeah, he's a lawyer and he passed the bar. I'm not denigrating him, but it's a whole different state. What he would do is not quite what we had to do here. So it's for some of these, it's hard to give specific answers because the place is different. And that's why it's important to reach out to individuals from that area or that state to get some of these specific questions. But I would look at the Family Search Catalog and the wiki. I would start there. And keep in mind, I generally look for a probate for anybody, because you just never, even you may think they didn't have a sent to their name, but there might, for some reason, something might have been there to generate a probate settlement. That you would want to look in the county where they were, the county lines changed, the county that it was in at the time the probate was started. If it drug on and there was a new county formed, I'd look in both counties, but it probably would be in the successor county. The same thing is true with land records. You're going to want, if the county lines have been changing, you'll want to look in all those counties.
Let's probably just answer one more question, if that's okay, Michael, and then we'll close this session for everyone. I think someone had raised.
It was the grantor. If you're talking about who to look for on the deeds in the index, the heirs on those deeds, the person who's selling the property is the grantor. So that's the index you'd want to look in the grant. I'm saying grantor on purpose so it rhymes with sell or, because people get those two words mixed up all the time. The grantor is the sell or when you're looking in those indexes. But I do thank you for your attention today. We appreciate that.
This was great, Michael. Thank you for taking the time to share your knowledge with every one of us. There were a number of comments as well. I hope you saw saying they appreciated everything that you shared, that it was really valuable, and they also liked your humor. So this is great.
I had to. I'm not used to giving present. I taught college for a long time, and I'm used to an hour and 15 minutes. So I'm really having to keep myself on task. So I was.
And you did great. You did really well. You did really well. Thank you for being mindful of that. Everyone, thank you so much for being here. Make sure to check out all the other live events that we have going on and all the classes that are available on rootstech.org. We hope to see you around in the next couple of days. Have a great day.
Thank you.